I'm Joe Corradino. I'm the chairman of the Board of Firearms Permit Examiners. I'm a holdover from the previous administration, so I'm a Republican, but Governor Malloy has not replaced me. Probably because, as Ed Peruta told you a little while ago, during the time I've been the chairman, we have cut the wait from about 22 months down to about 7 or 8 months for the hearing in front of the board. We worked very hard to do that. But obviously, my political view is something that you have to take into consideration when I tell you something. I'm also a criminal court prosecutor. Now, anything I say in this class does not reflect the opinions of the Division of Criminal Justice. Also, nothing that I say in this class reflects the opinions of the Board of Firearms Permit Examiners, or, because I'm the State Police Commissioner's designee to that board, it doesn't reflect the opinion of the Department of Emergency Services and Public Protection. So any opinion that you get is my opinion, and you need to know that up front. Right? Bear in mind that there is something in the classic Aristotelian logic called the argumentum ad veracundum, the argument from authority. Oh, this guy said this, therefore it's true, because he's the president, or he's a senator, or he's a doctor, or a professor. The person's title doesn't make something true. You have to examine the facts that support their opinion. And I would encourage you to do that with all of the speakers. You're going to get a very different view, probably, if we get into any policy questions, from me than you will get from Peter Cook, who's also on our board. Okay? We are probably at the extreme positions in most cases. And maybe one other member who may be more pro-law enforcement than I am. But my perspective is pro-law enforcement. Why is that? Because I work with criminal cases every day, and I see what crime does to people. So I have that perspective that I'm bringing into anything that I'm telling you. So I like to tell you what my biases are from. All right? Every person should strive to eliminate bias from their opinions and try to work fully with the facts. But that's often impossible. So I just wanted to give you that candid representation up front. Okay, here's what we're going to talk about. We're going to talk about how to get a pistol permit, what happens when you are either denied or revoked, and then we're going to touch basically on appeals to the Superior Court. Here's the process. In Connecticut, we don't have county government. We never did. In New England, there's never been a history of strong county government. The local unit of government is the town. Unlike the rest of the United States, and you probably don't know this, I didn't really pay much attention to it until I took a course in local government in law school. Here in New England, the universe is chopped up into towns. You cross one town line and you're in the next town. Out in other states, they don't have that. Towns are in the middle of unincorporated territory where there's no government other than the county. But here we have towns. And that kind of drives our process in Connecticut. We have a local issuing authority and a state issuing authority. The state issuing authority is the state police, the state police commissioner. The local issuing authority is a town authority, but he's issuing a state permit. This is not violative of any type of political theory that you might have. It in fact is consistent with our New England political theory that state functions are often carried out at the local level. For example, I noticed that Rachel has put up on the board some parts of the Connecticut Constitution. The Connecticut Constitution also guarantees a free public education. Public education is a state function, but it's carried out by local school boards. The town clerk in each town can issue fishing licenses, hunting licenses, and dog licenses. And these things are all established by state statute. The town clerk is carrying out a state function. So, in the pistol permit process, the local chief of police, where there's an organized police department, and in the 169 towns in Connecticut, not all of them have an organized police department. And where there is no organized police department, it's the first selectman. And those are the people who are the local issuing authority. Now, why is that? The reason behind that is the state police head office in Middletown knows that Litchfield County exists, that they have a troop out here, that they're responsible for some towns that don't have their local police departments, but The people at the licensing unit in Middletown do not know the people in Winston. They don't know the people in Harwinton. The local authorities know that. And so it's the local authority that carries out the crucial background investigation. And when the local departments are not doing that, if they're just looking for a punch list, check the boxes, you wind up getting a defective process. But the reason, in most departments, you do a reasonably good job of this, do a workup on the person who applies to make sure that the public safety is not going to be endangered by issuing a pistol permit to somebody. That's the suitability prong. We'll talk about that more later. And then there is the check the box. Do you have any of the disqualifiers? Okay? There's no such thing as a local permit. We used to have one years ago, and you could only carry within a town. That was done away with about 10 or 15 years ago. The temporary state permit that's issued in your town is valid only to carry a weapon. You can't buy a firearm. You have to get the permanent state permit. You have to be 21 years old, and that permit is valid for 60 days. If at the end of the 60-day period you haven't gone to Middletown to trade your temporary state permit for a permanent state permit, it expires, and you have to go back through the application process. And now, with the change of statute that took effect July 1, you can only make one application in a calendar year. So it behooves you, if you obtain a permit, a temporary state permit from your local issuing authority, to, in that 60-day window, go get your permanent permit. The permit application process. There is a standard form prescribed by the state police. That standard form cannot be added to in any way. And there's an opinion from the Attorney General in 1968 concerning that. Our board also did a declaratory ruling to amplify that, because some departments were requiring at the time of application that applicants provide them with credit bureau releases, general medical releases, letters of recommendation. The first two can be somewhat invasive into one's privacy, and the latter, letters of recommendation. If you're applying for a pistol permit, are you going to go and get the people who think you're a nut to write the letter of recommendation? No. So they were really valueless, but they were an extra hoop that the applicant had to jump through. And we've advised the chiefs that this is not permitted under our statute. Because pistol permits are a creature of statute, we have to adhere to the statute. Now, can the chief require additional information? Yes. When can that happen? Well, if the department is doing its job, the applicant is going to be interviewed. Because the department, the local issuing authority, has to make a finding that the person who obtains a pistol permit will make no unlawful use of the weapon that they are permitted to carry. How do you go about doing that in the absence of a crystal ball? You talk to the applicant. You find out about the applicant. And this goes back to why it's at the local level. The local police know who the town nuts are. Now, I'm not talking about the town nut who is at the dump on Saturday with a petition, because everybody goes to the dump and that's where you get your petitions on. Or the person that goes to the town meeting and gets the floor and talks about whether their pet grievances, even though it's not on the warrant. I'm talking about the people who the police respond to on a regular basis, but no enforcement action is taken, because one of the police officers are often referred to as peace officers. And they're there to keep the peace. And the town nut has done something absurd. That's not in a database anymore. You can't go to some centralized database and run somebody to find out how many times the cops went to their house because the radio is being played loudly, or they're out in the backyard photographing the neighbor. We've had cases like that. Because no enforcement action is taken, no arrest is made, there's not going to be something in a criminal justice database. Also, and this is the biggest defect in our system, if somebody has some type of mental illness, unless they've been adjudicated by the probate court, there's no record of that. You can have, just look this week at the Washington Navy Yard. That guy who, we have to say alleged, the person who is the shooter in that, apparently had some mental issue where he was in a hotel in Newport, and he called the police and he said that the people had a machine that was beating microwaves at him, and you know, this was certainly appears to be some type of psychotic issue. But since he was never arrested, and he wasn't posing a threat to himself, God bless you, so he wasn't committed to a hospital, there's no record of that anybody will find in order to revoke a pistol permit. For example, I think he held a pistol permit in Texas. Nor in the federal background check to purchase the shotgun that he purchased, will have pop up because we don't have the nut database. There's no such thing. But the local police chief and the local police department keeps track of all the calls they go to. And oftentimes it's by name or by address. So in the background check, they can run that. And they say, hey, we went to this guy's house a number of times. And then he talks to the officers and went there, what happened? Well, geez, you know, the wife or the sister or the mother said, you know, he's not taking his medication and he's got bipolar disorder and all this. And that may be buried in a police report someplace. So when that comes to light, then the local issuing authority can go back to the applicant and say, hey, listen, you know, we're advised that you have some type of history of a mental illness. Can you bring us something from your doctor that says that this isn't troubling you anymore? And there's a case on this. It's called State versus Basilicato. I'm sorry, Basilicato versus State. The guy was in West Haven, and the cop doing the background on him said, oh, you ever had any problems with, psychiatric issues? The guy said, I'm being treated for depression. He says, well, can you bring me something from the doctor that says that, you know, your depression isn't going to pose an issue if we give you a pistol permit, that, you know, you're a danger to yourself or others, and the guy wouldn't do it. He appealed to the board, and the board sustained the police department. This is almost 30 years ago. The Superior Court sustained the board, and the appellate court adopted the opinion of the trial court as its opinion, saying, yeah, this is appropriate. Why is that? Because the idea behind the permitting process is not to restrict a constitutional right. It is to implement a constitutional right, but balancing off the public safety aspects of it. This is why in Connecticut we have this concept of suitability. It fits in with also the check the boxes. It's not just, okay, he has no disqualifiers issuing the permit. There's a judgment call on the part of the issuing authority to talk about, is this person suitable? I'm going to talk about something. Other things, and I've gotten ahead of myself already, so we may click through some of the slides faster. There are certain disqualifiers, convictions, for example, any felony conviction. So that's a crime in either a state court or a federal court that no matter what your penalty actually was, if the court could have imposed a penalty of more than 1 year, that's a felony. Also, a judgment of conviction entered by a general court martial from the armed forces. Thank you.
You're welcome.
Certain mental health issues. If you have been committed by the probate court within the last 60 months, that's a statutory change, it used to be 12 months, or released within the last 20 years from a mental institution having been found not guilty by reason of insanity, those are automatic statutory disqualifiers. There's also certain misdemeanor disqualifiers. Those include a conviction for possession of marijuana under 21A 279A. It used to be that the misdemeanor convictions were a permanent bar. Now it's if you've been convicted within 20 years. So we used to get people coming up in front of the board who had a conviction for disorderly conduct.
when they were 18 years old, and now they're 48 years old, and they're applying for a pistol permit, and the chief denies them because they have this conviction. And they'd say, hey, this is remote, and we would order them to issue. Well, the statute now sets a look-back period for the misdemeanor convictions. You have to take, as Ed Peruta told you earlier, an NRA-approved pistol safety course, or one approved by the Commissioner of Emergency Services and Public Protection. I like to call it an Ed Peruta course.
I have it's bothering me because I have a really serious question.
Yeah.
If you decide you want to be a correctional officer or a police officer or whatever, but somebody has a history of mental illness, does that affect you getting that job in that field at all? Because you have to carry firearms and stuff, right?
I can't answer that specifically. It's kind of sort of wide of the mark. Certainly if I were the hiring person, I would take that into consideration. The question is whether or not that would be a disability that you were discriminating based on, or if it were a legitimate disqualifier. For example, if you have a bad back, you can't be a firefighter because you can't lift up hoses and climb up ladders and save people from burning buildings. The question is if you have some mental, either an Access 1 or Access 2 diagnosis, some disorder, some diagnosed disorder, whether or not that would be an impediment to a career in law enforcement, I don't know. But I know that it's an issue with respect to issuing pistol permits to people who
I do have a question on, because you said the breach of peace, what if he said, she said, and you end up with a restraining order? Does that affect?
It's a good question, and let me jump on the next slide, 'cause I think we might get there. I'll address it now. It's later in the presentation. If you have first of all, let's get our terms straight. People throw around terms like restraining order and protective order. In Connecticut, a protective order is what is issued when there is a domestic violence arrest. There's only certain categories of crimes that fit into domestic violence. And that is an order from the court that can actually put the people out of the house, but generally it only commands the person who's arrested to refrain from imposing any restraint on the person, the liberty of the person who's protected. And it also commands them to not harass, molest, assault, sexually assault that person. That lasts as long as the prosecution is pending. He said, she said cases very often result in either a diversionary program or the state does not pursue the case. There's mediation through domestic violence court. The person doesn't get a conviction. Well, if the case is nollied or dismissed, the protective order disappears. A restraining order is something different. A restraining order is something that is civil in nature, that a person can go and get, in Connecticut, ex parte. That means without the other party being present. They do it on an affidavit, and the judge issues it on the papers. That's only good for 14 days. The judge has to have a hearing within that 14 days to determine whether to continue the order or to let the order lapse. And so that restraining order type of situation, if there's one that's in place, that's going to be a bar. If you had one in the past, whether a protective order or a restraining order, and as a result of a conviction, the court can issue what's called a permanent criminal restraining order. That only comes with a conviction. And, if you have any of those in place, then it's going to be a per se bar to getting a pistol. If they were in the past and no longer operative, let's return to this slide here, you should disclose them and then explain the circumstances. We've had any number of people who had that happen to them in the past. There was a divorce going on, or the relationship was breaking up, and now it's several years out, the relationship is over, the person's out of the picture, they don't see them anymore, they haven't had any problem, they have a job, they're a responsible member of the community, well then, it's probably not going to be a problem. But if you are a regular customer at your local Part D courthouse, then it's probably going to, even though you don't have anything pending now, but you have lots of these things that happened in the past that didn't go anywhere, a frequent flyer like that, you're probably not going to get a pistol permit. The local issuing authority has 8 weeks to issue the permit. And the 8 weeks runs from receiving a sufficient application. Now, what's a sufficient application? An application that's correctly filled out, fingerprints, and the fees. So that's a sufficient application. It's not, it can be a constructive denial. If you have what's required and you want to submit it, and the chief doesn't take it because they only do pistol permits in a month with an R in them on the 3rd Thursday. You show up there and offer them the completed package, the clock starts, whether they take it or not. So, sir, you had a question.
I turned in on my paperwork like the first week of August. It took me like 14, 16 weeks to get my permit back.
I don't dispense advice on that in case something like that comes in front of the board. Mr. Peruta.
I'm going to answer his question only because it's timely.
Yeah, well, actually, why don't we answer it offline? Because he may have some particular issue he wants to talk to you about.
Okay.
That I don't want to know about in case it comes in front of the board.
Okay.
Okay. If your application is rejected and it's in proper form, or they don't give you an application when you ask for one, that's a constructive denial. You can take an immediate appeal to the board. Once you get that permanent permit, it's valid for 5 years. You may be rejected at the state police stage when you're taking your temporary state permit to convert it into a permanent one. And why is that? Well, if the chief is strictly following the statute and he has to issue, he's got 8 weeks to issue, so he has to issue. But there's some piece of information that was missing that comes to light in between. You can get a hold of the special licensing and firearms unit and say, hey, I've got this piece of derogatory information that came in after I had to issue the 8 weeks, but it really reflects on suitability. And the state police can deny you permit. In that case, you can take it to the court. Okay. Let me just cover 1 or 2 other ones of the disqualifiers because I covered most of them. Illegal aliens are not entitled to a state pistol permit, even though now they can get driver's licenses, and there's a moratorium on deportation in many states, including Connecticut, are restricting the ability of police departments to contact the immigration authorities. Illegal immigrants are still barred by statute from receiving a pistol permit. If you have been the subject of a firearms seizure warrant, sometimes people have an acute onset of some psychiatric disorder or something. It's usually self-destructive in nature. You might have some suicidal ideation or something like that. Very serious situations. And the police get a warrant to seize your firearms. That is a basis for denial. And then certain juvenile offenses. Okay, here's the misdemeanors. Possession of drugs, criminally negligent homicide. We're one of the few states that have a misdemeanor homicide, and that is as if you're negligent and you cause the death of somebody. So basically civil negligence. In most states, that doesn't give rise to being a crime. It's only a civil action. In Connecticut, you can actually get convicted of that. Assault in the 3rd degree, which is a misdemeanor. Assault on the 3rd on the victim 60 or older, which is the same thing except the victim is older. Threatening, reckless endangerment 1st, unlawful restraint 2nd, riot, inciting a riot, and stalking. So those are the misdemeanors. There's a federal prohibitor in there, and that is fairly rare that you see that, so it's not anything that I would worry about. And
I note in here that the statutory change. Okay. Okay. Who is not a suitable person? I like that one. I like that slide.
Not any of those people.
Not any of those people. Why?
They just, no.
It's like Justice Potter Stewart in pornography. You really can't put a definition on it, but you know it when you see it. These people are unsuitable for whatever reason.
The other thing is with that, like, it just, if you look at some of the faces like that in the criminal justice book that we have that we're doing now, what was it, the first chapter, the second chapter, there's a picture of a guy who looks like crazy at it. It was the one that shot
Gabriel.
Jim Rocker.
yeah.
Oh, the guy out in Colorado?
Yeah, the one that did all the shooting in
Yeah,
Lofton. Yeah, Lofton, did the shooting in the supermarket plaza. His look just looks exactly like not normal. There's something wrong with it.
Now, you have to be careful about
Yeah,
that.
that's discriminatory.
Yeah, you have to be careful about that. Because what is our norm? Okay? What is our norm? Do we discriminate against people on the basis of how they look?
No, but it was proven that.
Ah, it was proven! You are onto something here, aren't you? Hey, it was proven. Now,
It started with the crazy look, I
Yeah,
should say.
right,
It's
now-
like,
how many times in your life have you encountered somebody and their appearances were deceiving?
Yeah.
Alright, you got me there.
Yeah.
A lot.
Right. You know, it depends on the circumstances. You know, you look like the kind of guy, like after a six-pack, your judgment's going to be impaired, right? Looks are deceiving, right?
I was up
Then the cold, clear light of the hangover, you're, you know, oh my God, what did I do? Right?
No drinking, no, but I was up early this morning and as the look, shit, it looks like that.
Mhm.
The same, like working, so.
No, I'm saying that your perception of other people after the six-pack. That's what I'm saying. Yeah.
Oh.
The beer goggles.
Oh,
Yeah.
okay.
The humor can be subtle here. You know? I try to avoid it though. You cannot judge a book by its cover. You can also not judge people by their opinions, because it becomes very easy then to use people's religion or their political beliefs or their race to make government decisions. And you can't do that. You can't make governmental decisions with respect to these prohibited categories. Why is that? It's a constitutional question. One is the due process clause of the 14th Amendment, which applies to the states. Forget our state constitution, it says the same thing. The bare minimum is contained in the federal constitution. Secondly, and this has never gotten much of a workout by our Supreme Court, they've always avoided using the privileges and immunities clause because they've done it under due process. But if the government is discriminating based on who they like and who they don't like, that can be very problematic. And so we need to avoid that. So we can't just do things on the basis of looks, you know? All right? So, who's a suitable person? The person is suitable by reason of his character, his reputation in the community, his previous conduct as a licensee, because remember, we hear revocations too, is shown to be suited or adapted to the orderly conduct of a business, which the law regards as so dangerous to public welfare that its transaction by any other than a carefully selected person duly licensed is made a criminal offense. Specifically in the context of the firearm permit, the statutes clearly indicate a legislative intent to protect the safety of the general public from individuals whose conduct has shown it's what you said about evidence, to be lacking the essential character and temperament necessary to be entrusted with a weapon. Now, there's also cases that say it's not simply a matter of, sometimes the perception of the board, the perceiving people, enters into that. Just how you judge the credibility of a witness. You see somebody take the witness stand. Why do you believe that person? Why do you not believe that person? Well, yeah, it could be based on the quality of their testimony. they say X and 10 other people said Y. Could be that they're confronted with their own inconsistent statement. Could be that they have a history of testifying falsely. But it could also be their manner of testifying. You know? So what's your name? Why do you want to know that? You know? As opposed to being straightforward and frank. If they seem evasive, if they don't seem to be telling the truth. How many of you have children? Okay. Can you tell when the kids are telling you the truth? Right. Okay. The board, however, and a police chief who's denying something, has to be able to articulate the reason why we don't think they're telling the truth. So it can't be, it's a little bit more than my gut, but your own observations of the person can enter into that. Why? Because laws do not exist merely on paper. Laws exist to be used by people with rational faculties, right? So the issuing authority or the board, in the same way that a cop makes a stop on the street, he has to have reasonable and articulable suspicion to make a stop. He has to be able to say what it was that caused him to make the stop. But a lot of that is his professional experience as a police officer. It's, again, those of you who have children who read Madeline, Miss Clavel says, something is not right. Okay? So it's the something is not right, and what is the something that's not right? So it's this perception. It's not simply a cold hard check the numbers list. Mr. Cook will tell you that he has a problem with suitability. I think suitability is the touchstone of our permitting process, because otherwise it would just be rubber stamping, and you would take away the discretion that the issuing authority should be using in protecting public safety and issuing permits. The decision cannot be arbitrary. I don't like you. We had a case come up one time on the board. It's a young guy in his mid-20s, and he had no criminal convictions, he had a couple of encounters with the law because he lived in a little town. And up here at this end of the state, you guys are all from little towns. The police officers know a lot more about the few people that live in the town than in a big city where there's a lot more people who know things about it. So in the little town, the kid in high school had some friends that were problems and got pinched. In fact, one time the kid's car had been pulled over and they served a warrant on his friend. And his brother had gotten arrested and prosecuted for something. But this guy had nothing wrong. And he was in the process of buying a house, he was in the process of getting married, he had a responsible job for a contractor with a state agency that was taking care of, I think it was special needs kids or something. So he'd been vetted by the agency in order to get that job. And he, in addition to working, was pursuing education at the same time. The guy's doing everything he's supposed to do, okay? So the decision by the police department to deny the permit in that case, at least to the board, and the board was unanimous on this, appeared to be arbitrary. It was done because, he knows a guy that's a no good thing. And that doesn't satisfy the requirements of the due process of law. You have to take into consideration in making these determinations as a public actor, the conduct, judgment, character, reputation, habits, behavior, physical condition, mental condition, and previous conduct of the person. Okay. So that's the important thing. I like this 1882 citation, and I often put it in the opinions of the board. Suitability is not defined by the law so that that its application can be determined as a mere matter of eyesight, but it is left necessarily to be determined solely by the judgment of the commissioners based upon inquiry and information. So that's the standard. Okay. If you are denied revoke, you have 90 days to appeal to the board. There is no specific form. You can put it on a wet napkin and mail it to Susan, our staff person, and that will initiate your appeal process. It's a simplified procedure. The idea behind it
is that it's going to get, it's the idea of giving due process. I don't know how many of you have you had a course in constitutional law? Anybody here? The U.S. Supreme Court started down this road of due process requires a trial-type hearing. The case Matthews versus Eldridge is the touchstone case on this. And then they backed off of the trial-type hearing so that it was, okay, if you're going to take away public support benefits, social benefits, you need to have a trial-type hearing. When they realized that government is in the process of denying people all the time for different types of things, you would bring government to a grinding halt. They changed the standard, at least for non-social welfare benefits. And that is a post-deprivation hearing with notice and an opportunity to be heard. So that's the bare minimum that a person would be able to get if government denied them something to which they believe themselves entitled. So if a police chief, after interviewing you and handling your application, denied you, theoretically, you could, if you were in the legislature, you could pass a bill that said, once a person gets denied, they can take an administrative appeal to the Superior Court for the decision of the police chief. But what that does is that it brings into play the court system. And the court system is very cumbersome. In fact, I heard, and the idea there is that we're giving notice and hearing to somebody, and giving them an opportunity to be heard. Then, if you don't resolve it in a way that is satisfactory, you can go to the Superior Court. The board has well, actually, up until July 1, the board was authorized 9 members. We still have 9 members. The 2 vacancies haven't been filled yet. There are 2 public members. That means people who are not affiliated with anyone in any organization in any way. Currently, one of the public members is a retired police officer. The other is a retired lawyer from New York who was a Navy fighter pilot. They are appointed by the governor. Then there's the state police representative. That's me, also appointed by the governor, but on nomination from the Department of Public Safety. There is a representative of the Department of Environmental Protection who is the colonel of the conservation police, the conservation officers that you encounter in state parks or if you're hunting or out on the water. And then a representative of the Police Chiefs Association, Connecticut Chiefs of Police Association. The current representative is the retired chief of Weathersfield, and he actually has also been elected by the fellow members of the board as the secretary. I was appointed by Governor Rell as the chairman. Originally, I was just a member, and I served as secretary for a short time. Then there are 2 sportsmen's organizations that have statutory membership on the board. Ye Connecticut Gun Guild and the Connecticut State Rifle and Pistol Association. And that rounds out the membership up until July 1. The General Assembly changed the membership and composition of the board with the gun legislation that went through in the spring in the wake of the horrible events in Newtown. And they decided that a retired judge appointed by the chief court administrator would also serve on the board. And the commissioner of mental health and addiction services would nominate a person with a psychological background, hopefully with a psychological background, and the governor would appoint that person. I don't know what the retired judge is going to add to the mix other than having another legal point of view. I think it's significant, this is opinion now, folks, I think it's significant that the legislature has chosen to put somebody with a mental health background on the board. Because a substantial number of our cases are mental health type cases. Whether it's the police responding to suicidal threats by a person, whether it's somebody who's had a history of mental illness. Those are the very difficult cases that we have.
And it's going to be helpful to have somebody with that type of expertise to sort through the mental health issues. Some of the people on our board have some experience with this. I, in my real job, handle cases for our office with the Psychiatric Security Review Board. But I'm no psychologist, I'm no psychiatrist. I kind of have a nodding acquaintance with the terminology. But to have somebody who is a clinician, hopefully we'll get a clinician serving on the board, I think it's going to be an asset. If you take a look at the Psychiatric Security Review Board, we in Washington State are the only two states that have that. If a person is acquitted by reason of mental disease or defect, or what we used to call not guilty by reason of insanity in criminal court, in other states they're committed to the state hospital, and then the trial court manages whether they stay, whether they get let out. We have a board that if you're committed to the state hospital after being acquitted of a crime, they can't move you from one board to the other without going to the board. The board has an attorney that presides over it, it has some public members, and it has 3 or 4 psychiatrists and psychologists that serve on that board. And they scrutinize the decisions of the hospital to move people around. And they make recommendations based on their expertise to the Superior Court. And I have a hearing coming up next week in one of those type of cases. That's a good model, and I'm glad that they've added this mental health person to the Board of Firearms Committee examiners, because that's an area of expertise we can tap into in dealing with people who have mental illness. Mr. Peruta, 5 minutes?
5 minutes.
Oh, okay, let's see. Okay. We inquired de novo into the proceedings. That is, we don't take the police chief or the state police decision in the way that the appellate court takes the decision of trial. If you have a lawsuit and you lose, and you take an appeal, when it gets up to the appellate level, the appellate court is going to look at it in the light most favorable to sustaining the verdict of the trial court. The board has a different standard. And sometimes the chiefs get a little angry about this, but we have to follow the statute. And that is de novo. In Latin, that means over to do. It's a do-over. It means from the beginning, or a new proceeding. And so the government official, whether it's the local chief, the selectman, or the state police, have the burden of proof in front of the board, and that is by preponderance of the evidence. That's the civil standard. A new change is that the statute will allow for continuances for good cause shown for the issuing authority. They won't get defaulted if they're not ready to go on the first hearing. They can show why. We had last year somebody that said, "Listen, we cleaned up from the hurricane. We couldn't put guys on, get ready for hearings." And we understand that. Our process is adversarial. The witnesses are examined by both parties. They can confront and cross-examine. It's also a summary format. It's not a trial. It's designed to give a speedy adjudication. And we do follow the Uniform Administrative Procedures Act. We talked about that. I talked about that. We do not decide constitutional questions. My friend Mr. Cook very often will generate these. We don't do that. It's not our mission. We are limited by the statute in determining whether there exists a disqualifier or whether the person is suitable. Those are the 2 things we decide. That's it. Okay. All right. We make our decision at the hearing. We send notice in writing. The meetings are open to the public. So, for example, if you file an appeal, you've now put the issue, Mr. Peruta was talking about freedom of information before. You have put the question in issue. So by doing that, you've opened the door to peek into, I take the position, I disagree with Ms. Baird. I think an application for a pistol permit is not disclosable because it does turn into a permit in most of the cases. And why would you make available all the applicants and not make available the permittees if you're trying to keep bad guys from getting a list of houses to break into, you know?
May I respond?
May I respond?
So that's my position on it, but let me finish my thought, and then we can.
Oh,
On the
really?
other hand, you put into issue and then open for public scrutiny when you appeal to the board the facts surrounding the chief's decision. Because it's important to shed sunlight onto the administrative process. Now what happens is that you wind up on CTN and your neighbors all find out about you going to the doctor, or what gave rise to your divorce, or all that kind of stuff. So your dirty laundry is going to be aired and people can see it. And that's subject to public scrutiny, and it's not protected. It's subject to freedom of information. Yes, Mr. Peruta?
As far as pre-valid permit privacy, the Connecticut State Legislature should address the issue, or everybody else should comply with the law. If they wanted to exempt people who apply for pistol permits, the legislature should have said so. That's my opinion.
And that's why this is a great country. We're all entitled. So you can be as wrong as you want.
I know, shall means may, right?
Absolutely, and I can give you a case that says so. Let me just cover these, because I know I'm bumping up against my time here. A couple of suitability issues. First of all, we decide these on a case-by-case basis. So it's just like when you have a car accident and you go into the lawyer, and the lawyer says, geez, your case is really only worth about $2,500. And you say, well, my uncle, he had the frame of his 1992 Buick bent, and he got $60,000. That's your uncle's case. It's not this case. So each case is different, so outcomes may differ. This idea of saying I've never been arrested. Under Connecticut law, you're allowed to say I've never been arrested if you've used one of our 7 or 8 diversionary programs, and so you got arrested 7 or 8 times, but each time they've been thrown out, or they were nollied and dismissed. You can say you've never been arrested. But what happens is, those fingerprints that were taken when you were arrested, they went to the State Police Bureau of Identification, and the State Police Bureau of Identification's fingerprints were wiped. But before they were wiped, they were sent to the FBI. And nothing ever disappears at the FBI. It's always there in the file, and it shows that you had an arrest. It doesn't say what for, it doesn't say when, but that's going to come up. So it's always been my advice that if you were arrested, tell the people who are asking, especially if you're going into law enforcement and you're going to take a polygraph exam, tell them, yeah, I was arrested. But here's what the outcome was. It got to court, the prosecutor realized that it wasn't my fault, that the cops rounded up all the kids walking down the street because of a noisy college party, and when they got to court, the prosecutor threw out every case. And you know what? Every one of us has been in that situation at one point or another, and people realize that. So, my lawyer told me there are many, many people who appear in front of the bus who are prepared to throw their lawyer appear in front of the board that are prepared to throw their lawyer under the bus and blame their lawyer's advice. The lawyer's advice was good at the time that you got it. It doesn't apply to the situation that you're in now. So it's not, lawyer advice isn't one size fits all. I didn't know that I was convicted. We hear this all the time. I didn't know that I was convicted. If you paid a fine, if you went on probation, even if you never reported to a probation officer, you were convicted. And I forgot about it. That's a tough one. We don't buy that often. Okay, I talked about that in the beginning. Oh, we look to the actual conduct involved, not the way it was adjudicated, and we're allowed to do that. So just because you didn't get convicted, we can look at what happened and what brought the police there. We can give it what weight we think it deserves. If it deserves minimal weight because nothing really happened with it, okay, we'll do that. But we can consider these things. Okay. We talked about that. Safe storage issues, we'll save for another day because I don't want to run into the next
person. This type of stuff, aberrant conduct, like I started with, the town nut, the person who just doesn't conform to the expectations that are appropriate in a certain circumstance, even if it doesn't rise to the level of a crime, that can be reason for denial, because that's a proxy for other problems. Also, maturity. Alcohol abuse is an issue with us. And misuse, dangerous conduct, accidental discharges, unsafe storage, all that type of thing. Improper transfer.
Mr. Corradino?
Yep, I know.
No?
Oh,
Well, we are out of time, but this has been so interesting that I want to let the class know that you can actually go watch Mr. Corradino in action. Do you know how you can do that? The first Thursday of every month, the Board of Firearms Permit Examiner sits at the Wethersfield Police Department. It's open to the public. If you go there, you will see all 7 board members lined up at a table. You will see a room full of approximately 50 police officers and civilians, people who have either been denied their permit or been revoked, police officers, civilians, all interspersed. You'll see the state police detectives from the firearms unit lined up against the wall. You'll see an attorney from the state police who is representing the Department of Public Safety. And then you'll see attorneys like me, or a lot of people actually go on their own. They don't even have attorneys. Mr. Corradino will be sitting in the middle, directing the meeting, and that is really the best way to learn how the Board of Firearms Permit Examiners work. They start at noon, and they have been known to go to 5 o'clock in the morning.
For the next morning.
4:55 in the morning. So if you're number 16 or 17 on the agenda, you are sitting there for 10 to 12 hours waiting for your case. They've tried to cut back on that now, though, because there have been complaints.